All right, let's get right into it. We're going to talk about what is, for sure, the most important framework you use every single day: statutory nuisance. We're going to break down the legislation that gives you your power and really map out the specific tools you have in your kit to protect your communities. Okay, so for you, this is ground zero, right? Pretty much every investigation, every site visit, it all kicks off with a piece of paper that looks a lot like this one: a complaint. So today, we're going to unpack that powerful legal toolkit that lets you turn this piece of paper into a real solution. So here's how we're going to break it down. Think of it like a tour of your professional toolkit. We'll start with the legal lay of the land. Then we'll zero in on the one crucial test you have to apply every time. After that, we'll literally open up the toolkits for premises and for emissions, figure out the boundaries of your powers, and then we'll wrap up by looking at the impact you have. First things first, let's get our bearings. Now, you know there are a few different types of nuisance in law, but for us, the one that matters, our bread and butter, is statutory nuisance. It's all laid out for us in Part 3 of the Environmental Protection Act 1990. This right here, this is the foundation for everything you do. Okay, now this next part is absolutely key. Before you can even think about which tool to use or what notice to serve, you have to run the complaint through a core legal test. This is the filter, the gateway that every single case has to pass through. So imagine you're out on a visit. You're standing there, taking it all in. The fundamental question you have to ask yourself is this: does what I'm seeing, smelling, or hearing right now legally count as a statutory nuisance? And that isn't about what you personally think is annoying. It's about a very specific legal definition. And the law gives you this really clear two-part test. For something to be a statutory nuisance, it has to tick at least one of these two boxes. It's either 1, prejudicial to health, or 2, it's a nuisance in the common law sense. And that either or is what makes this so powerful. It lets you tackle things that are a direct health risk, but also things that just make someone's life a misery. And this is brilliant because it comes from case law that really helps us out. The courts have looked at that phrase, prejudicial to health, and they've clarified it. Your job isn't to prove that harm is definitely going to happen. You just have to establish a real possibility of it. That's a much broader and, frankly, a much more powerful standard for you to work with. Okay, let's pop open the first tray in that toolkit. We're talking about the powers you have to deal with problems that relate directly to the physical state of a property or a piece of land. So here are your 4 main tools for this. A good way to remember them is to think about the fabric of a building, what's on the property, the life being kept there, and any infestations. So the fabric itself is covered by state of premises. What's on the land is your accumulation or deposit power. The life is your animals tool. And finally, infestations coming from business premises are covered by your insects tool. Let's dig into a couple of these. Now, this first one, state of premises, is huge. It's your go-to for health risks that are part of the property's actual condition. Think really bad damp and mold that could cause respiratory infections. But, and this is crucial, you have to know its limits. This isn't for things like trip hazards or personal injury. And it's not for bad design or lack of facilities, like a missing hand basin. That stuff falls under a whole different set of rules, usually the Housing Act. Next up is your accumulation or deposit tool. Honestly, this one is so versatile. It's your power for dealing with just piles of stuff that have become a problem. We're talking anything from building rubble left on a site to bags and bags of domestic rubbish piling up in a garden. Okay, let's move on to the next tray in the toolkit. We've just looked at the state of a property. Now let's look at the tools you have for what's coming from a property. We're talking about emissions. First up, and let's be honest, this is a classic: smoke. This is probably one of the most common complaints you get between neighbors, and you have a specific power to deal with it. So what does smoke actually mean in the eyes of the law? Well, the Act defines it as soot, ash, or gritty particles. The key thing here is that the power kicks in when that smoke is emitted from one premises and it's causing a problem for neighbors. It's all about the impact on other people. So beyond smoke, you can think of your other emissions tools as kind of a sensory shield for the community. You've got powers for what people are breathing, so that's fumes, gases, dust, and smells coming from commercial properties. You've got a power for what they're seeing, like intrusive security lights angled right into a bedroom. And of course, the big one, you have a power for what they are hearing, noise. Now, noise is really interesting because of how you have to apply the law in domestic situations. It all comes down to the reasonable user test. The principle is basically give and take between neighbors. You know, life is noisy. So normal, everyday living sounds are not a statutory nuisance. And this is where your professional judgment is so important, because you're the one who has to decide where that line gets crossed. You know, any good tradesperson doesn't just know their tools, they know the limits of their tools. And it's the same for you. Understanding where your statutory nuisance powers stop and where another law takes over is absolutely essential. And this table just lays out a few of those key boundaries. Like we said, bad design in a house, that's Housing Act territory. Big industrial sites with what are called prescribed processes, they're regulated by the Environment Agency, not you. And dark smoke from chimneys has its own very specific law, the Clean Air Act. Knowing this stuff saves you a ton of time and makes sure the right people get involved from the start. And finally, there's this really handy little subsection. Think of it as a gateway. It basically says that if some other law declares a problem to be a statutory nuisance, it automatically gets added to your toolkit. The classic example of this is a defective drain, which is covered under the Building Act 1984. So we've had a good look through the whole toolkit. Let's just step back for a second and think about your role in all this. You're the one on the ground, the skilled professional who actually picks up these legal instruments and uses them to make a difference. And really, it all comes back to this. It comes back to that initial test. It's your professional judgment, your thorough investigation, your ability to stand there and say, yes, there is a real possibility of harm here. Or, yes, this legally constitutes a nuisance. That is what protects public health. That's what gives people a better quality of life. Every single day, a new complaint email pings into your inbox, and you reach into this exact toolkit. You assess the situation, you apply that legal test, and then you select the perfect instrument to solve a problem, resolve a conflict, and make your community a healthier and safer place. So what challenge are you going to solve next?